Howdy LinkedIn, this is Kyle Griggs at Snell and Wilmer. Wanted to follow up on my last video where we talked about the recent trends that I've been seeing among startup tech companies and things startup tech companies might do to protect their technology. And this time I want to talk about naming your technology. A lot of tech startups come up with something that's truly innovative on the practical side, but struggle just a bit with giving it a name that speaks to their customer base. And there's really two things that you need to pay attention to. One, picking a name that is both protectable and also not used by somebody else, and then protecting the name once you already pick it. So very often somebody will work with a branding company to develop a list of a few potential names and then work with counsel to screen those names and protect them. Usually a good tech startup product name suggests some feature, some compelling benefit of the product, whether it's speed, efficiency, something about the feature set, but it does not describe it. You do not want to merely describe something about your product. You want to suggest some superlative feature your product may have. And we can see that in many of the social media apps. They use a logo that might suggest connectivity or velocity. You can see this with many of the green tech products. They suggest some sort of conscientiousness or some sort of efficiency. We can see that with many of the crypto and Bitcoin related startups. They suggest something sophisticated or something associated with financial prosperity. However, in none of these instances do they merely describe their product. That's important. Endeavor to pick a name that suggests a product characteristic but does not describe it. Now, okay, you've picked a name. You need to make sure nobody else is already using that name, or one that a reasonable consumer might become confused with respect to. So it doesn't have to be that you copy someone's name directly to still have potential infringement liability. This is where it's real important to work with counsel. We can screen your name and provide you an assessment of the relative risks associated with the different names you're considering. Then the second piece, protect that name. In many jurisdictions, including the US, you have common law trademark rights and you have a federal registration system. Under common law, as soon as you begin using that name with that product in trade, you're developing some rights. However, they're typically limited to the jurisdictional bounds of your market. So, if you're selling in Texas, you'll have rights in some or all of Texas. However, with the internet providing a global marketplace, you likely want bigger rights than that. A federal registration will protect your rights nationwide and give you a starting point to use certain international treaties to go global. Now, you don't have to be using the mark with the product yet to file your application to federally register the mark. So, as soon as you settle on a name, it's prudent to file that registration. You do, however, have to demonstrate use in commerce within a certain time period thereafter. Now in the United States, the time period is very, very generous, so typically you'll want to pick a name, file your registration, and then get back to the lab and finalize your product. You don't have to be fully market ready yet to start taking the steps to protect the name that you will take to investors, that you will use with your initial marketing collateral. Just like you want to get out in front of your public release with your patents and your technology protection, think about doing the same thing with your names. Okay, that's my message for today. I will talk to you next time.